Part-11 Judiciary 126 Courts to exercise powers relating to justice. Powers relating to justice in Nepal shall be exercised by courts and other judicial institutions in accordance with this constitution, other laws, and recognized principles of justice. All shall abide by the orders or decisions made by courts in the course of hearing of lawsuit. 127 Courts. There shall be the following courts in Nepal: Supreme Court, High Court, and District Court. In addition to the courts referred to in Clause 1, judicial institutions may be constituted at the local level to try cases under law, or other institutions as required may be formed to pursue alternative dispute resolution methods. 128 Supreme Court. There shall be a Supreme Court of Nepal. The Supreme Court shall be a court of record. All courts and judicial institutions shall, except as otherwise provided in this constitution, be under the Supreme Court. The Supreme Court shall have the final authority to interpret this constitution and laws. The Supreme Court may inspect, supervise, and give necessary directives to itself and courts, the specialized courts, or other judicial institutions under its jurisdiction on matters relating to administration of justice or management. All shall abide by any interpretation of the Constitution or law made by or any legal principle laid down by the Supreme Court in the course of hearing a lawsuit. In case anyone makes obstruction in the dispensation of justice or disregard any order or judgment handed down by it or any of its subordinate courts, the Supreme Court may, in accordance with law, initiate proceedings of contempt and impose punishment therefor. 129 Appointment and qualification of Chief Justice of Nepal and Justices of Supreme Court. The Supreme Court shall consist of a maximum of 20 justices in addition to the Chief Justice of Nepal. The President shall appoint the Chief Justice on recommendation of the Constitutional Council and other justices of the Supreme Court on recommendation of the Judicial Council. Any person who has served as a Justice of the Supreme Court for at least 3 years shall be eligible for appointment as the Chief Justice. The term of office of the Chief Justice shall be 6 years. 5. Any citizen of Nepal who has obtained a bachelor's degree in law and served as the Chief Judge or a Judge of a High Court or at least 5 years, or who has obtained a bachelor's degree in law and constantly practiced law as a senior advocate or advocate for at least 15 years, or who is a distinguished jurist having constantly worked for at least 15 years in the judicial or legal field, or who has served in the post of gazetted first class or a higher post of the judicial service for at least 12 years shall be deemed to be eligible for appointment as a Justice of the Supreme Court. Explanation: the period during which one has served as the Chief Judge or Judge of an appellate court prior to the commencement of this Constitution shall, for the purposes of this clause, be deemed to be the period of service in the capacity of the Chief Judge or Judge of the High Court. In case the office of the Chief Justice falls vacant or the Chief Justice is unable to carry out the duties of his or her office by reason of illness or otherwise, or he or she cannot be present in the Supreme Court by reason of a leave of absence or his or her being outside of Nepal, the senior-most Justice of Supreme Court shall act as the acting Chief Justice. 130. Conditions of service and facilities of Chief Justice and Justices. In case the Chief Justice or a Justice of the Supreme Court who has served for at least 5 years resigns or undergoes compulsory retirement or dies, he or she shall be entitled to such pension as may be provided for in the federal law. Except otherwise provided for in this Constitution, the remuneration and other conditions of service of the Chief Justice and Justices of the Supreme Court shall be as provided for in the federal law. Notwithstanding anything contained in clauses 1 and 2, the Chief Justice or a Justice of the Supreme Court who has been removed from the office by way of impeachment or who has been punished by a court for a criminal offense involving moral turpitude shall not be entitled to gratuity or pension. The remuneration and other conditions of service of the Chief Justice or a Justice of the Supreme Court shall not be altered to his or her disadvantage, provided that this provision shall not apply in cases where a state of emergency is declared because of extreme economic disarrays. 131. Vacation of office of Chief Justice or Justice of Supreme Court. The office of the Chief Justice or a Justice of the Supreme Court shall fall vacant in any of the following circumstances: in case he or she tenders resignation in writing to the President, in case he or she attains the age of 65 years, in case a motion of impeachment is adopted against him or her pursuant into Article 101, in case the Chief Justice or Justice of the Supreme Court is relieved of his or her office by the President, in the case of Chief Justice on recommendation of the Constitutional Council, and in the case of Justice of Supreme Court on recommendation of the Judicial Council on the ground that he or she is unable to discharge his or her duties because of physical or mental illness. In case he or she is punished by court for a criminal offense involving moral turpitude, in case he or she dies. 132. Chief Justice and Justice of Supreme Court not to be engaged in any other office. No Chief Justice or Justice of the Supreme Court shall be engaged in or deputed to any office other than of a judge, provided that the government of Nepal may, in consultation with the Judicial Council, depute a Justice of the Supreme Court to work concerning judicial inquiry or to legal or judicial investigation or research for a specified period. No person who has once held the office of Chief Justice or Justice of the Supreme Court shall be eligible for appointment to any government office except as otherwise provided for in this Constitution. 133. Jurisdiction of Supreme Court. Any citizen of Nepal may file a petition in the Supreme Court to have any law or any part thereof declared void on the ground of inconsistency with this Constitution, because it imposes unreasonable restriction on the enjoyment of any fundamental right conferred by this Constitution or any other ground, or to have any law or any part thereof made by a provincial assembly declared void because it is inconsistent with any law made by the federal parliament, or to have any law or any part thereof made by a municipal assembly or rural municipal assembly declared void because it is inconsistent with a law made by the federal parliament or the provincial assembly. The Supreme Court shall have an extraordinary power to declare such law to be void, either ab initio or from the date of its decision, in case the law in question appears to be so inconsistent. The Supreme Court shall, for the enforcement of the fundamental rights conferred by this Constitution, or of any other legal right for which no other remedy has been provided for, or for which the remedy, even though provided, appears to be inadequate or ineffective, or for the settlement of any constitutional or legal question involved in any dispute of public interest or concern, have the extraordinary power to issue necessary and appropriate orders, provide appropriate remedies, enforce such right, or settle such dispute. Under the extraordinary jurisdiction referred to in Clause 2, the Supreme Court may issue appropriate orders and writs, including the writs of habeas corpus, mandamus, certiorari, prohibition, and quo warranto. Provided that, except on the ground of absence of jurisdiction, the Supreme Court shall not, under this clause, interfere with any internal proceedings of the federal parliament or provincial assembly, and with any proceedings instituted by the federal parliament or provincial assembly concerning violation of its privileges and penalties imposed therefore. Subject to this Constitution, the Supreme Court shall, as provided for in the federal law, have the power to originally try and settle cases, hear appeals, test judgments referred for confirmation, revise cases, hear petitions or review its judgment or final orders. While so reviewing the judgments, justices other than those having handed down the previous judgments shall make such review. The Supreme Court shall have the power to settle appeals from cases originally heard and settled by a high court and matters of public importance involving questions of interpretation of the Constitution and law, or cases recommended by a high court, accompanied by its opinion that it is reasonable that decision be made by the Supreme Court. Other powers and procedures of the Supreme Court shall be as provided for in the federal law. 134. Power to transfer cases. In case the cases which involve substantially the same questions are sub judice before the Supreme Court and High Court, and the Supreme Court is satisfied on its own or on application by the Attorney General or parties to such cases that such questions are of public importance, the Supreme Court shall have the power to procure and adjudge the cases together. In case there exists a special circumstance where judicial impartiality may be questioned if a case filed in High Court is heard by that court, the Supreme Court may, stating the results and grounds thereof, order such case to be transferred from such High Court to another High Court and be heard by the latter High Court in accordance with law. 135. Not to engage in practice of law. No Chief Justice or Justice of the Supreme Court shall, after retirement from office, be engaged in the practice of law, mediation, or arbitration proceedings before any office or court. 136. Responsibility of Chief Justice. The Chief Justice shall have the ultimate responsibility to make effective the administration of justice by the Supreme Court, sovereign courts, specialized courts, or other judicial institution. 127. Constitution of Constitutional Bench. There shall be a constitutional bench in the Supreme Court. The constitutional bench shall consist of the Chief Justice and other 4 justices designated by the Chief Justice on recommendation of the Judicial Council. The bench referred to in Clause 1 shall originally hear and settle the following cases in addition to the petitions filed pursuant to Clause 1 of Article 133. Disputes relating to jurisdiction between the Federation and a province, between provinces, between a province and a local level, and between local levels, disputes relating to election members of the federal parliament or provincial assembly, and matters relating to disqualification of a member of the federal parliament or of the federal provincial assembly, notwithstanding anything contained in Article 133, in case it appears that any case sub judice in the Supreme Court involves the question of serious constitutional interpretation, the Chief Justice may appoint such cases to be heard by the bench referred to in Clause 1. Other provisions leading to the functioning of the constitutional bench shall be as determined by the Supreme Court. 138. Annual Report. The Supreme Court, Judicial Council, and Judicial Service Commission shall submit every year annual reports to the President, and the President shall submit such reports to the Federal Parliament through the Prime Minister. In case the Federal Parliament, upon deliberating on the annual reports submitted pursuant to Clause 1, deems it necessary to give any suggestion, it may give such suggestion to the concerned institution through the Governor of Nepal, Ministry of Law and Justice. Other provisions relating to annual reports referred to in Clause 1 shall be as provided for in the federal law. 139. High Court. There shall be a High Court in each province in case anyone makes obstruction in the dispensation of justice by or disregard any order or judgment handed down by it or any of its subordinate courts, judicial institutions. The High Court may initiate proceedings on and impose punishment for contempt as provided for in the federal law. Each High Court shall consist of such number of judges in addition to the Chief Judge as provided for in the federal law. 140. Appointment and qualification of Chief Judge and Judges of High Court. The Chief Justice shall, on recommendation of the Judicial Council, appoint the Chief Judge and Judges of the High Court. Any citizen of Nepal who has obtained a bachelor's degree in law and served as a judge of district court for at least 5 years, or who has obtained a bachelor's degree in law and constantly practiced law as a senior advocate or advocate for at least 10 years, or who has constantly been engaged in the teaching or research of law, or in any other field relation to law or justice for at least 10 years, or who has served in the post of at least gazetted first class of the judicial service for at least 5 years, shall be deemed to be eligible for appointment as the Chief Justice or a judge of the High Court. Appointments to the Chief Judge and Judges of a High Court shall be made from amongst the persons who have possessed the qualifications referred to in Clause 2 on the basis of the proportion of cases settled by him or her annually and of evaluation of cases upheld, quashed, or reversed by superior courts in the course of final decision thereof, in the case of a district judge and of his or her seniority, qualification, and evaluation of a standard or performance of business, in the case of a person who has served in the post of at least gazetted first class of the judicial service, and of evaluation of seniority, professional continuity, honesty, professional conduct, and contribution made to the field of law and judge in the case of others. In case the office of the Chief Judge falls vacant or the Chief Judge is otherwise unable to carry out the duties of his or her office or cannot be present in the High Court by reason of leave of absence or his or her being outside of the province, the senior-most judge of the High Court shall act as the acting Chief Judge. 141. Conditions of service and facilities of Chief Judge and Judges. Except as otherwise provided for in this Constitution, the remuneration and other conditions of service of the Chief Judge and Judges of the High Court shall be as provided for in the federal law. Notwithstanding anything contained in Clause 1, the Chief Judge or a Judge of High Court who has been removed from office upon action taken by the Judicial Council or upon punishment by a court of a criminal offence involving moral turpitude shall not be entitled to gratuity or pension. Provided that these provisions shall not apply in cases where the Judicial Council has removed him or her from office on the ground of inability to perform the duties of his or her office because of physical or mental illness. The remuneration and other conditions of service of the Chief Judge or a Judge of the High Court shall not be altered to his or her disadvantage, provided that these provisions shall not apply in cases where a state of emergency is declared because of extreme economic disarray. 142. Vacation of office of the Chief Judge or Judge. The office of Chief Judge or Judge of a High Court shall fall vacant in any of the following circumstances: in case he or she tenders resignation in writing to the Chief Justice, in case he or she attains the age of 63 years, in case he or she is relieved of office by the Chief Justice on recommendation of the Judicial Council on the ground of his or her incompetence, misconduct, failure to perform his or her duties, honestly, performance of business with malafide intention or serious violation by him or her of the code of conduct required to be observed by him or her, in case he or she is removed from office by the Chief Justice on recommendation of the Judicial Council on the ground that he or she is unable to discharge his or her duties because of physical or mental illness, in case he or she is convicted and punished by a court for a criminal offense involving moral turpitude, in case he or she dies. A judge who is facing a charge shall be provided with a reasonable opportunity to defend himself or herself prior to removing him or her from the office pursuant to subclause C of Clause 1. The judge against whom the proceedings have been so instituted shall not be allowed to perform the duties of his or her office until the proceedings are completed. Nothing shall bar the institution of action in accordance with the federal law against the chief judge or judge who has been removed from office for an offense which he or she has committed while in office. 143. Chief judge and judges not to be engaged in any other office and provisions relating to transfer. No chief judge or judge of a high court shall be engaged in or deputed to any office other than that of judge, provided that the government of Nepal may, in consultation with the Judicial Council, depute a judge of the High Court to work concerning judicial inquiry or to legal or judicial investigation or research or to any work of national interest for any specific period. The Chief Justice may, on recommendation of the Judicial Council, transfer a judge of a High Court to another High Court. 144. Jurisdiction of the High Court. The High Court shall have the power to issue necessary and appropriate orders for the enforcement of the fundamental rights conferred by this Constitution or for the enforcement of any other legal right for which no other remedy has been provided or for which remedy, even though provided, appears to be inadequate or ineffective, or for the settlement of any legal question involved in any dispute of public interest or concern. For the purposes of Clause 1, the High Court may issue appropriate orders and writs, including the writs of habeas corpus, mandamus, certiorari, prohibition, and quo warranto, provided that except on the ground of absence of jurisdiction, the High Court shall not, under this clause, interfere with any internal proceedings of the Federal Parliament or Provincial Assembly, and with any proceedings instituted by the Federal Parliament or Provincial Assembly constituting violation of its privileges and penalties imposed therefor. The High Court shall, in accordance with the federal law, have the power to originally hear and settle cases, hear appeals, and test judgments referred for confirmation. Other powers and procedures for the High Court shall be as provided for in the federal law. 145. Power to transfer cases. In case a High Court is of the opinion that a case which is sub judice in a subordinate court within its jurisdiction involves a question relating to a provincial law, and it is essential to settle that question in order to decide the case, the High Court may procure the case and dispose the case wholly or decide only such question and remand the case to the court of first instance. In case it is satisfied with the reason that there exists a situation where judicial impartiality may be questioned if a case filed in the district court is heard by that court, the High Court may stating that the reasons and grounds thereof order such case to be transferred from such district court to another district court under its jurisdiction and heard by the latter district court as provided for in the federal law. 146. Allowed to be engaged in practice of law. A person who has retired from the office of a judge of High Court may be engaged in the practice of law before the Supreme Court and High Court, other than the High Court and subordinate courts where he or she has served as a judge. 147. Responsibility of Chief Judge. The Chief Judge shall have the ultimate responsibility to make effective the administration of justice by the High Court and the courts or other judicial institutions which are subordinate to it. For that purpose, the Chief Judge may, subject to this Constitution and the federal law, gives necessary direction to the subordinate courts and judicial institutions. 148. District Court. There shall be a district court in each district. The local level judicial institution established in accordance with the provincial law shall be subordinate to the district court. The district court may inspect as well as supervise and give necessary direction to its subordinate judicial institutions. 149. Appointment, qualification, remuneration, and other conditions of services of judges of district courts. The Chief Justice shall, on recommendation of the Judicial Council, appoint judges of the district courts. The vacant posts of the judges of the district courts shall be fulfilled as follows: 20% of the total vacant posts on the basis of evaluation of seniority, qualification, and competency from amongst the officers who have obtained bachelor's degree in law and served for at least 3 years in the post of gazetted second class of the judicial service. 40% of the total vacant posts on the basis of open competitive examination from amongst the officers who have obtained bachelor's degree in law and served for at least 3 years in the post of gazetted second class of the judicial service. The remaining 40% of the total vacant posts on the basis of open competitive examination from amongst the citizens of Nepal having obtained bachelor's degree in law have constantly practiced law for at least 8 years as an advocate for who having obtained bachelor's degree in laws have served in gazetted post of the judicial service for at least 8 years or have constantly been engaged in the teaching or research of law or served in any other field of law or justice for at least 8 years. The Judicial Service Commission shall, in accordance with the federal law, hold written and oral competitive examinations for the purpose we have possessed the qualifications referred to in sub-clauses B and C of Clause 2 and make recommendation in order of merit to the Judicial Council for appointment as district judges. The remuneration and all the conditions of services of the judges of the district court shall be as provided for in the federal law. The remuneration and all the conditions of services of a judge of the district court shall not be altered to his or her disadvantage, provided that this provision shall not apply in cases where a state of emergency is declared because of extreme economic disarray. The office of judge of a judge of the district court shall fall vacant in any of the following circumstances: in case he or she tenders resignation in writing of the Chief Justice, in case he or she attains the age of 63 years, in case he or she is removed from office by the Chief Justice on recommendation of the Judicial Council on the ground of his or her incompetence, misconduct, failure to perform his or her duties honestly, performance of business with maleficent intention, or serious violation by him or her of the code of conduct required to be observed by him or her, in case he or she is removed by office by the Chief Justice on recommendation of Judicial Council on the ground that he or she is unable to continue service and discharge his or her duties because of physical or mental illness, in case he or she is convicted and punished by a court for a criminal offense involving moral turpitude, in case he or she dies. A district judge who is accused shall be given as a reasonable opportunity to defend himself or herself before removing him or her from office pursuant to subclause C of clause 6. The district judge against whom the proceedings are so initiated shall not perform the duties of his or her office under the proceedings are completed. Nothing shall prevent the instituting of an action in accordance with the federal law against the district judge who is removed from office or the offense which he or she has committed while in office. 150. District judges not to be engaged in any of the office and provisions relating to transfer. No district judge shall be engaged in or deputed to any office other than that of judge, provided that the government of Nepal may, in consultation with the Judicial Council, depute a district judge to work concerning judicial inquiry or to legal or judicial investigation or research, and to any election related to work for a specified period. The Chief Justice may, on recommendation of the Judicial Council, transfer a district judge from one district court to another district court. 151. Jurisdiction of district court. Except as otherwise provided for in the federal law, a district court shall have the power to initially hear and settle all cases under its jurisdiction, to hear petitions under law, including petitions of habeas corpus and injunction, hear appeals under law from decisions made by quasi-judicial institutions, hear appeals from decisions made by local level judicial institutions formed under the provincial law, institute contempt proceedings and punish for contempt under the federal law in case anyone makes obstruction in the dispensation of justice by or disregards any order or judgment by it or any of its subordinate courts. Other provisions relating to the jurisdiction and procedures of the district court shall be as provided for in the federal law. 152. Specialized courts. Other specialized courts, judicial institutions, or tribunals may be constituted to initiate and settle specific types and nature of cases other than those referred to in Article 127 as provided for the federal law, provided that no specialized court, judicial institutions, or tribunals shall be constituted for any specific case. No criminal offense involving imprisonment for a term of more than 1 year shall fall under the jurisdiction of an institution other than a court, specialized court, military court, or judicial institution. 153. Judicial Council. There shall be a Judicial Council to make recommendations or give advice in accordance with the Constitution or on the appointment of transfer of disciplinary action against and dismissal of judges and other matters relating to the administration of justice, which shall consist of the following as its chairperson and members: the Chief Justice chairperson, the Federal Minister for Law and Justice member, the senior-most Justice of the Supreme Court member, one jurist appointed by the President on recommendation of the Prime Minister member, a senior advocate or advocate who has gained at least 20 years of experience appointed by the President on recommendation of the Nepal Bar Association member. The term of office of the members referred to in subclause D and E of clause 1 shall be 4 years, and the remuneration and facilities shall be equivalent to those of the Justice of the Supreme Court. The members referred to in subclause D and E of clause 1 shall be removed from office in the same manner and on the same grounds as the Justice of the Supreme Court. Chairperson and a member of the Judicial Council may study the case associated with the complaint filed in respect of any judge and make a report thereof to the Judicial Council. In case a preliminary inquiry of a complaint filed in respect of any judge reveals the need to have a detailed inquiry by an expert, the Judicial Council may form an inquiry committee. In case a judge other than a judge may be removed from the office by way of impeachment in accordance with this Constitution commits the abuse of authority by way of corruption, the Judicial Council may investigate into the matter and institute a case in accordance with law. The Judicial Council shall be required to prepare operative records of the person who are qualified for appointment to offices of the Chief Justice, Justices of the Supreme Court, and Chief Justice, and Judges of the High Courts. Other functions, duties, and powers of the Judicial Council shall be as provided for in the federal law. 154. Judicial Service Commission. The government of Nepal shall, in appointing, transferring, or promoting gazette officers of the Federal Judicial Service, or taking departmental action concerning such officers in accordance with law, act on recommendation of the Judicial Service Commission. Provided that the government of Nepal shall consult the Public Service Commission for new permanent appointments to gazetted posts of the federal judicial service from persons who are not already in the federal government service, or for promotions from non-gazetted posts of the federal judicial service to gazetted ones of that service. For the purpose of this article, the Public Service Commission shall hold open and joint competitive examinations to be held for appointments to gazetted posts of the federal judicial service. The Judicial Service Commission shall consist of the following as its chairperson and members: the Chief Justice chairperson, the Federal Minister for Law and Justice member, Senior Most Justice of Supreme Court member, chairperson of the Public Service Commission member, the Attorney General member. Other functions, duties, powers, and procedures of the Judicial Service Commission shall be as provided for in the federal law. 155. Provisions relating to conditions of services and facilities. Provisions relating to the remuneration, facilities, and conditions of services of the employees of the Federal Judicial Service shall be as provided for in a Federal Act. 156. Provisions relating to Provincial Judicial Service Commission. Provisions relating to the formation of a Provincial Judicial Service Commission and the remuneration, facilities, and conditions of service of the employees of a Provincial Judicial Service shall be as provided for in the federal law.